Hello everyone and welcome to the first Brodie's Energy Academy session of our autumn series. Today we're going to be telling you what you need to know about climate change litigation. My name is Rona McFarlane and I'm a partner in the oil and gas team at Brodie's. The session today is on climate change litigation and we'll cover different types of climate change litigation in the oil and gas sector, recent case law, and the environmental, social and governance issues that arise in climate litigation. My partner Neil McLean will be talking to you today. Neil is a partner in our litigation team with a broad range of experience and has advised clients on a number of significant pieces of environmental litigation, both in the UK and internationally. So Neil, over to you.
Thank you very much for that introduction, Rona. So as Rona said, what we're looking to cover today is climate litigation, looking at it both from an international perspective and also some developments in the UK, and really trying to identify the trends that we see there and how those might impact on the energy sector. And as part of that consideration, I'm going to look at ESG considerations, so environmental, social and governance considerations and how those interact with climate litigation. And then I'm finally going to draw together some conclusions from the sector from all of that. One thing I did want to say at the outset is that I recently spoke at the Oil and Gas UK conference on a similar topic. And I have looked at the attendees for today, and I see that some of our attendees were at that session as well. I do just want to say that I am going to cover some fresh ground in this session, and I'm going to speak about things that I didn't have time to cover in that session. So hopefully there will be something new and of value to you, even if you did attend the conference a couple of weeks ago. Okay, so moving on then to talk about what do we mean by climate litigation. As I've said on the first slide here, I take that to mean a broad range and type of legal proceedings that relate in some way to climate change and its effects. So it includes litigation before the courts, but also regulatory bodies and their tribunals. In other jurisdictions, there are specialist environmental tribunals who deal with these sorts of issues. It's not included for the purposes of the figures that I'm about to mention, but it would equally include any complaints mechanism that is used to report a climate change issue. And we now see complaints mechanisms founded on ESG principles. And I'll talk a bit about that in the section on ESG later on. We have an annual report that's prepared by the London School of Economics, and I've included a quote from that on this slide. The report is in its third year and looks at global trends in climate litigation, and it's come up with some fairly stark numbers. What we see is that globally, the cumulative number of climate change related cases is more than doubled since 2015. Just over 800 cases were filed between 1986 and 2014, well, over 1,000 cases have been brought in the last 6 years. So there you can see, really quite significant upturn in climate change litigation. And if we move on to look at what does that mean in terms of a geographical spread, well, you can see from the map on the slide that the sort of darker colours indicate where the most cases are. So a lot of litigation in the US, as you would expect, in Australia and in Canada. But if you look at the UK, in the middle of the map, it's a sort of orange colour with 65 to 70 cases. But what we're expecting to see is the UK to also become one of those darker coloured countries and one of the most active jurisdictions for climate change litigation. I'm now going to move on to talk about the different types of climate change litigation we see, because they reflect the sorts of climate change litigation that's occurring worldwide and likely to occur in the UK as well. And I've grouped those into sort of three categories. The first is actions against government, and describing that as strategic litigations. And it's strategic because it's aimed at bringing about some broader societal shift. These cases are sometimes, but not always, linked to emissions targets and the Paris Agreement. And we see that the number of strategic cases is dramatically on the rise, and that's reflected in the LSE report I mentioned a moment ago. Strategic cases are typically brought by NGOs and pressure groups, and they're generally, as I've said, brought in order to hold governments to account for perceived failures in relation to climate change. And there have been a run of successful challenges in the last 12 months. And if you look at the split in the LASE report, around 50% of these strategic cases have been successful worldwide. The second category is actions against decision makers. And this is the most common and well-established type of challenge, and it's generally challenges to decisions to grant licenses, permits, or planning permission. And it's of clear relevance to the energy sector, which is heavily regulated and for which licenses and permits, etc., are required. And the third category is actions in the private sector, and that's distinct from the above because it's not directly about government or decision makers, although it can be related to action they've taken. These are cases that are brought directly against a private sector company or financial organization, and there's more diversity being used in the arguments in those cases. And really, we're seeing those cases on the rise because of implemented ESG reporting obligations and an awareness of ESG principles more generally, core of which is environmental protection. And I'll say a bit more about ESG later on and how that interacts with this type of climate change litigation. So moving on to start then by looking at the international strategic litigation that we see. I mentioned the run of successful challenges a moment ago. It's not on the slide, but that run really starts with a challenge by the NGO, the Urgenda Foundation, against the Netherlands in December 2019. And in that case, the Dutch Supreme Court ruled that the Dutch government had to reduce Dutch emissions by a minimum of 25% by 2020 compared to 1990 levels. It found that the Dutch government's failure to take responsibility for the Netherlands' contribution to the climate crisis was a breach of its obligations under the European Convention on Human Rights. And that was followed in April 2021 by a decision in Germany where the German Constitutional Court struck down parts of the German Climate Change Act. And what the court said in that case is that the proposed act was incompatible with fundamental constitutional rights because it failed to set sufficient provisions for greenhouse gas emissions cuts beyond 2030, and so prejudiced future generations because it failed to take precautionary steps and it offloaded major emission reduction burdens onto periods after 2030. So this is an argument we see a lot in strategic climate change litigation, an intergenerational argument that it is the younger generation that is going to have to bear the brunt of climate change, and that what you can't do is push emission targets back into periods after 2013. The court in that case required a revised law to be enacted by the end of 2022, and the German government has brought forward new legislation to comply with the court's ruling. And that was followed in July 2021 by a challenge brought in Belgium by Belgian NGOs and Belgian citizens. And again, similar arguments made about the Belgian state's failure to take sufficient account of greenhouse gas emissions. And the argument in that case was that failure constituted both a breach of Belgian civil law and also the European Convention on Human Rights. The court found that there had been a breach, but because of particular issues around the constitutional settlement in Belgium, declined to make an order specifying certain reduction targets. And there has also been a similar challenge in Ireland in July 2021, where the Irish government's national mitigation plan fell short and was quashed by the court. The argument being that the plan itself was, as the court described, vague or aspirational, and the court said lacked sufficient specificity as to the policy over the whole period to 2050, not just the first 5 years. So the court critical there again of plans not being concrete or clear enough in later years. And I could continue talking about actions in Brazil, Canada, France, and all over the world, really, where we see strategic litigation being brought against states. And I suppose the question then is, well, why does that matter to the energy sector and the oil and gas sector in particular? Well, successful challenges to government policy obviously have the potential to have a knock-on effect in terms of the regulation of a sector, and can impact on decisions taken by government, like decisions to grant licenses for oil and gas extraction, and particularly if changes are made to targets. Okay, so move on to the international private sector, and this is the third of the three categories I talked about, and potentially the most interesting. What we had here is a challenge brought by several NGOs, including Friends of the Earth, against Shell. So here we have the NGOs, rather than raising proceedings against the state for a perceived failure, raising proceedings directly against a private company. The NGOs made a number of allegations in their complaint, principally that Shell's contribution to climate change and the targets it had set itself violated Shell's duty of care under Dutch law, and also obligations under the Human Rights Act. And what the NGOs wanted the court to do was to order that Shell had to reduce its overall CO2 emissions by at least 45% from 2019 levels by the end of 2030. So a fairly stiff target there. The Dutch court ruled in favour of the NGOs and ordered Shell to reach that target reduction. And it's the first time, as many viewers of this webinar will be aware, that a court has ordered a company to reduce its CO2 emissions in line with the climate goals included in the Paris Agreement. The court's decision is based on Dutch civil law. However, in its assessment as to whether Shell had actually contrary to Dutch civil law, the court also looked at international frameworks such as UN guiding principles, and it also took into account the European Convention on Human Rights. So use a broad range of international law frameworks as well as domestic law in order to reach its decision. And on the factual side, the court took into account the potential consequences of Shell's CO2 emissions, and also Shell's influence over end-use CO2 emissions. The court found that Shell would act contrary to the Dutch civil law and its so-called unwritten duty of care, which is in that code, if it did not reach the reduction and an order that Shell had to. It said two things. It said that Shell was found to have what the court called an obligation of result for the activities of the Shell Group, and that means that Shell must ensure that its group companies reach the proposed reduction. But it also had what the court described as a significant best efforts obligation with respect to business partners of the Shell Group, including end users. So that entails taking necessary steps to remove or prevent the serious risk resulting from CO2 emissions generated by Shell's business partners, and Shell using its influence to limit any lasting consequences of such emissions as soon as possible. So imposing on Shell a burden to look at its supply chain as well. A couple of things that I just wanted to highlight that, that in terms of argument that Shell advanced, and a quite interesting argument about a level playing field. One of the arguments Shell had, of course, is that it has no control over the emissions of its group companies or end users, and it can't be held liable under Dutch law for the emissions of those actors. Shell also argued that the court shouldn't make the order because it wouldn't lead to an actual reduction in CO2 emissions, as third-party companies would simply just step in to meet the demand for fossil fuels and other products. And then a key piece of Shell's argument was that imposing the reduction obligation on it would lead to unfair competition and a disruption of the level playing field in the oil and gas market. The court's response to that was to say that Shell had failed to specify the detail of that argument. And what the court also said is that Shell's argument ignored that it was necessary to reduce the worldwide oil and gas extraction in order to curtail CO2 emissions that cause dangerous climate change, and that the court expected that other companies will also have to make a contribution. Shell had obviously argued that imposing this reduction on it alone would curb the potential for growth, and that would be unfair because other companies in the sector would not face that challenge. Court acknowledged that the effect of the order is that it could curb Shell's growth. However, it said the interest served with the reduction obligation outweighs Shell's commercial interests. And it said that, I'm quoting from what the court said, due to the serious threats and risks to the human rights of Dutch residents and the inhabitants of the Wadden region, private companies such as Shell may also be required to take drastic measures and make financial sacrifices to limit CO2 emissions to prevent dangerous climate change. So the court did engage in a balancing exercise and considered that threat and risk to human rights really trumped the commercial interests of Shell. And if we move on to, you'll see a quote, I suppose, that summarizes the court's views. I mean, the court, on the one hand, acknowledges Shell can't solve the global problem on its own. However, that doesn't absolve Shell of its individual partial responsibility to do its part regarding the emissions of the Shell group, which it can control and influence. So shortly after the decision, Shell announced it would appeal the court's decision, and it will be interesting to see what happens next. I mean, the decision of the Dutch court is a decision of its district court or divisional court, so not the Dutch Supreme Court as we had in the Urgenda case. So it's not a court of appeal, and it would be interesting to see, obviously, what the Dutch Supreme Court makes of this decision and whether it's upheld or not. But in the meantime, of course, until that takes effect, Shell has this judgment against it, and will obviously have to reflect, no doubt, carefully on what that means for meeting the emissions targets that are contained in Shell's policy documents. So that's what's happening internationally. Let's just move on to what's happening in the UK. And before I get into some specific examples of cases in the sector that are relevant, I do just want to say a bit about the grounds of challenge in the UK, because that's important if we look at, well, what will we get decisions like the Shell case in UK litigation. So in the UK, challenges mainly have to be brought by judicial review or statutory appeal. And that's generally because the challenges are being brought against either the state or decision makers. So those first two categories that we've talked about. There are some exceptions to that, of course. Certain types of permitting appeal will be brought before inspectors or reporters appointed by the government. And the distinction is of some significance, because if a case is brought by judicial review or statutory appeal, that is a challenge about the legality of the decision-making exercise. It's not a decision about the merits of it. So you aren't able generally to overturn or review decisions that have been taken about which facts a decision maker preferred, for example. And I'll just highlight a few examples of the types of challenge that we see. I'm not going to go into all of these in detail. So there are generally three grounds of challenge in a judicial review. The first is illegality. So that's saying a decision is unlawful in some way. The second kind of challenge is irrationality. So that's saying a decision is so unreasonable that no decision maker would take it. And the third type of challenge we commonly see is a challenge that says a decision is flawed for procedural grounds. And I'm going to focus on the first and last of those with some diagrams. So in terms of illegality, well, what I've got on the slide here is all the different types of challenge you can see in a petition for judicial review that says something is unlawful. I'm not going to go through each of these, and I wouldn't get too hung up about them either. These are just different ways of labeling something as unlawful, and the grounds of challenge frequently overlap. Probably the most common out of them all is the first one, which is saying something as ultra vires. There's a general rule that public authorities must act within the limits of their powers, and if they act beyond those powers, then they are acting ultra vires. And just to use a hypothetical example, the Oil and Gas Authority has certain powers concerning the regulation of offshore upstream petroleum activity in the UK. The Oil and Gas Authority has the power to grant licenses that confer exclusive rights on the licensee to search and bore for and get petroleum. So if the Oil and Gas Authority issued licenses without that power being in place, then it would be acting ultra vires. So there you have an example. You have an authority that's acting within its powers because it's got a specific power to do it. But it can also just mean doing something that is unlawful. So it's ultra vires for a public authority to act in a way that's incompatible with human rights, and as well as being a breach of the Human Rights Act. And many of the judicial reviews in this area are likely now to be about breaches of human rights, and we see that as an emerging trend internationally. And I mentioned obviously the agenda case, the German case and the Belgian case a moment ago, all brought on human rights grounds. Another common type of challenge is a relevant considerations challenge. Sometimes that's easy if a statute or policy lists factors that must be taken into account and one is omitted, then you fail to take into account a relevant consideration. In planning terms, these are described as material considerations, but sometimes it's not so easy to spot. But example of something that's not listed but would always be relevant would be, for example, environmental evidence, impact on certain species or birds. You would have to normally take that into account as a decision maker granting licenses for this sector. What's important though is once the right factors have been identified, how much weight to be given to them is a matter for the decision maker. It's really difficult to overturn just how a decision maker has actually treated the evidence, and I'll say a bit about that in a moment with reference to one of the example cases. And the final example I just want to draw out from this list is fettering of discretion, which basically just means that you can't have a blanket policy and each case must be considered on its own merit. So again, using the Oil and Gas Authority as an example, it couldn't have a policy that said it would only accept license applications of a certain type and always decide them in the same way. A public authority always has to be prepared to take into consideration exceptional circumstances in any application it decides. The three other grounds are less likely to be relevant. I've included them for the sake of completeness. I want to move on to talk then about procedural challenges. Again, this is really common in this area. And on the left-hand side, what we have is statutory procedural requirements that are mandatory or directory. So if you have a statute that says, for example, in relation to this license application, you must consult a list of statutory consultees, and you fail to consult one of them, then that challenge could be overturned on procedural grounds. But even if you don't have that obvious list of statutory requirements that needs to be complied with, it can also be overturned on common law procedural grounds. And again, there are various rules, and I don't want to go through them all, given time. But the most common here is likely to be legitimate expectation, and in particular, a legitimate expectation to consultation on changes. So again, to use an example, the oil and gas industry might have a legitimate expectation it would be consulted on any substantive changes to regulation of the industry. And if, for example, government was promoting policy without consulting the industry, then that sort of decision could be challenged on procedural grounds. I've not put it on this slide, but often what you'll see is a combination of all of these types of grounds. So you will see challenges to the lawfulness of decision making, you'll see procedural challenges, and often you get an unreasonableness challenge thrown in. So you'll see challenges that talk about even if the petitioner or challenger is wrong about it being unlawful, that it's in any event unreasonable, and that's just often brought as a make way alongside other grounds of challenge. There is a potential fourth ground of judicial review, proportionality, but it only applies in certain circumstances, and I'm not proposing to cover it today. So those are the grounds, and I wanted to take you through those, really because they're important to have in mind when you're thinking about whether a challenge in the UK is going to be successful or not. So let's turn now to look at some examples of challenges in the UK. And I want to start with a strategic challenge to the UK emission scheme. And I want to start with that because it gives, as I've said, an indication as to how the courts in the UK might approach similar challenges. So this is a decision from June of this year, and it was a challenge brought by an environmental campaigner and UNESCO Special Envoy, Georgia Elliott-Smith, to the UK emissions trading scheme. And that was introduced to replace the equivalent EU scheme. She argued that the initial cap of 156 million tonnes of CO2 was considerably above the amount expected to be emitted by various sectors, and that was incompatible with the short and medium-term climate obligations set out in the Paris Agreement. And the court in that case followed well-established principles of judicial review, the first of which was that the Paris Agreement was an unincorporated international treaty, so it wasn't the role of the court to resolve questions of its construction. The approach that had been taken by the government to the Paris Agreement was described by the court as being tenable and entirely appropriate because it didn't deny the urgency of the need to address climate change and involved the recognition that taking measures in the short to medium term was an essential part of that. Thinking again about the points I made about relevant, irrelevant considerations a moment ago, one of the things the court recognised is that the government had undertaken significant detailed modelling work, and because of that, the court found that it wasn't appropriate to go and look behind that modelling, particularly where no rival modelling or criticisms of that modelling work had been advanced by the petitioner in the case. So what you have there is the court saying, we think the government has identified the right factors, it's produced evidence, it's not for us to look behind that evidence and get involved in resolving factual disputes. We're only concerned here with the legality of what the government has done. And the court was satisfied that the scheme itself fulfilled the purposes of its governing legislation and fell within the scope of the powers available to the government. So again, finding that it was lawful and intra vires as opposed to ultra vires. But that's the first of a growing number of cases coming to the courts brought by environmental campaigners and challenging government action. There's a challenge that's due to come before the courts brought by Plan B, Earth 3 young people for judicial review, and that is a claim that the UK government has violated their human rights to life, to family life, and to be free from discrimination in the way in which the UK government is implementing the Paris Agreement. And the claim form mentions a number of actions, including support for opening new coal mines, financing of fossil fuel projects, reducing support for international communities exposed to climate risks and impacts. So a fairly broad range of challenges relevant to various sectors. Probably more directly relevant to the oil and gas sector in particular is, of course, the challenge to the consent given to BP for the development and production of the Vorlich field. That was a challenge brought in Scotland. It was heard last month. And it's of my sort of three categories, it's the more traditional challenge you see, a challenge to a decision maker to grant a permit. As part of the permit process, the government was required to review an environmental impact assessment. And what Greenpeace, who are challenging the decision, are saying is that that process must obviously consider the environmental impact of the proposed oil and gas project, but it also must look at that in the context of other projects with similar cumulative environmental impacts, including emissions resulting from the burning of the fossil fuels that will be extracted. And Greenpeace is also arguing there was a failure to properly consult on the decision to grant the permit. So again, thinking back to the grounds of review we talked about, that would be a procedural ground of challenge. And the government response is arguing, amongst other things, that the legal duty to consider indirect impacts of oil drilling did not extend to emissions coming from burning oil extracted. So that's just too remote from what the government was trying to do. And also, that's just an irrelevant consideration, again, if we think about the grounds of challenge I've talked about a moment ago. And the final one I want to mention is a challenge brought in May 2021 by climate change campaigners to the Oil and Gas Authority's new strategy. So that was laid before Parliament in December last year, came into force in February of this year, and it gives the OGA a mandate to secure maximum value of economically recoverable petroleum from beneath relevant UK waters, but also, and it's a dual mandate, to take appropriate steps to assist the Secretary of State in meeting the net zero target. In that case, the claimants are arguing that the plan is irrational. So the third ground of judicial review, because it's inconsistent with the UK's net zero target, because the effect of that plan will lead to more oil and gas being extracted than otherwise be the case. Permission for that challenge to go ahead has been granted, and we'll have to wait and see what the court makes of it. So what conclusions do I take from that? Well, the environmental impact of the energy sector and the oil and gas industry in particular is widely recognised, and government measures have been initiated to mitigate it. The oil and gas sector in particular is likely to be in the front line when it comes to climate change litigation, both because it applies for permits and licenses, but also because of the rise in actions taken directly against private sector companies. However, all that said, we're still waiting for a successful UK challenge on pure climate change grounds, and that is perhaps reflected in the nature of the challenges and the grounds of judicial review and statutory appeals that are available. So I want to move on just to, before I close the session, to talk a bit about ESG. So ESG has featured as a separate webinar in the past in this Academy series, but what I want to focus on is how ESG interacts with climate change litigation. So set against those trends that I've just talked about a moment ago. So if we move on, we'll see the three categories of ESG, and a reminder that it's used by investors really to evaluate companies and determine also the future financial performance of those companies. Obviously, the most relevant for our discussion today is the first one, which is environmental, and it covers all the things you would expect: climate change, natural resources, pollution and waste, but also environmental opportunities. And the environmental criteria is used obviously to evaluate environmental risks that a company might face. On the social criteria, probably of most relevance is what it says about business relationships. So suppliers wanting to work with suppliers that hold the same values, and that the way that a company behaves in terms of its people and its social opportunity reflects those values. And finally, in terms of governance, though, that's obviously just ensuring you've got proper, accurate and transparent governance within a business or organization, and that just broadly that engage in the right type of behavior and don't engage in unlawful or illegal practices. Investors are urging companies obviously to build ESG considerations into their long-term strategy, and they're bringing it up during engagements and using shareholder proposals to force companies to take action. So we see that across the world as well. On the next slide, I've got the principles of responsible investment. And just a reminder that that PRI is a UN-supported international network of investors, and it's signed up to by over 4,000 asset owners, investment managers and service providers, managing assets of over $121 trillion. This slide shows the 6 principles for responsible investment, and I just want to highlight principle 3, which it requires investors to seek appropriate disclosure on ESG issues by the entities in which we invest. So there you have investors saying that they are going to look for disclosure of ESG issues by the entities in which they invest. So a reporting obligation there. So why is that important for the sector? If we just move on and think about the risks, well, one of the things that's interesting here, of course, is that I've talked about climate change litigation. So on the one hand, you have pressure from environmental campaigners and those seeking to challenge government and licenses and permits granted by government, and also now to challenge directly private sector companies for their emissions targets. So you've got that on one side, but you also within an organization and from above it have pressure from investors and shareholders to comply with ESG principles. So the risks of getting it wrong are significant. I mean, clearly one of those is reputational harm. There's a reason there are so many signatories to the PRI. It just simply reflects broader societal changes to environmental issues in particular. A significant ESG event can be hugely damaging to a company's reputation. And of course, that could then impact on share price, resulting in billions of dollars potentially in associated losses. It also might have an impact on licenses. An ESG event, again, can lead to denial or withdrawal of licenses, and a bad track record is obviously likely to result in tougher regulatory action. And on licenses, it's worth noting the OGA's consultation from 20th September this year on its proposed governance guidance. And that's the guidance that sets out the factors which will usually be considered by the OGA when considering the adequacy of a licensee's governance arrangements. The purpose of the consultation, as explained by OGA, is to assist the UK government in meeting its net zero target by having in place good environmental, social and governance practices in their plans, so in the licensees' plans and operations. And the OGA also explains within the text of that consultation that there's obviously a heightened interest in good environmental, social and governance disclosures and reporting, and concludes by saying industry's social license to operate is under increased scrutiny, and the OGA can and should make clear the value of good ESG and influence best practice in this area. So what you see now is a regulatory expectation that ESG principles will be embedded in the oil and gas sector. Another risk is obviously investment. Investors will want to protect their investments by only investing in organizations with strong adherence to ESG principles. And it's clear to see that investors are making decisions following ESG criteria, and they're doing that partly because they've signed up to the PRI, but also because it allows them to avoid investing in organizations whose practices could signal a risk factor. So you don't want to invest in an organization that has a significant ESG event and a lack of controls to prevent that, because you may lose out on your investment. Similarly, joint venture partners are likely to want to pair up with organizations that adhere to ESG principles. And finally, there is the potential for enforcement action. And I don't really want to talk about regulators there. Really, what I'm interested in is it's becoming increasingly common to make ESG complaints to the lenders of companies in traditionally heavy industries. And what you'll find is that those lenders have set up ESG complaints mechanisms, sometimes with independent expert panels that will rule on whether the lender has complied with due diligence principles and whether it has in fact received sufficient reports from the organisation it's lending to. And that's another way of putting pressure on companies, because it's likely to include issues around enforcement of banking covenants and also the ability to lend in future. And it's just to me a different type of climate change litigation, because although you're not using a tribunal or a court, the outcome from a complaints mechanism like that is likely to be in the public domain and could also be reputationally damaging. But I want to close on a more positive note. The flip side of that is that, equally, if you get all of that right, ESG can have a positive impact on reputation. That makes you more attractive when tendering for projects and more attractive to investors. So there are big prizes if your organization gets ESG right, and also it reduces that risk of the different types of climate change litigation I've talked about, be it in the courts, tribunals, or through lenders' complaint processes. So drawing that all together and sort of conscious of time, what do we take as a conclusion from all of that? Well, strategic litigation against government, emerging trend on the rise, and the figures I started this session with from the LSE are fairly significant. You see a huge rise in the amount of strategic litigation being brought, and that is directed generally against governments. But within that, what we see is actions against companies. And it'll be interesting to see if that does become a trend. Obviously, Shell has had its level playing field argument. The court in the Netherlands suggested that there will be others, and it wasn't the case that Shell was being singled out. But we're waiting to see whether that sort of litigation is repeated in other jurisdictions and against other companies, but it does seem likely, having seen the success in the Netherlands, that others will follow suit. The energy sector is likely to be impacted by all types of climate litigation. I said a moment ago, it's very much in the front line, and it is susceptible to challenge as part of strategic litigation, action directly against companies, but also the sort of softer complaint type challenge that I talked about a moment ago. Need to be mindful, obviously, of ESG obligations, but those offer rewards as well if you get it right. So it's not all negative. So that's all I really wanted to say. Obviously happy to take any questions. I've also got a bit of time left, and see Rona has appeared to ask me some questions, hopefully.
Yeah, thanks very much, Neil. That was really interesting. It's easy to see why there's potential for this type of litigation to increase as we progress through energy transition. So let's see what questions have come in for you. So you've mentioned an increase in the number of challenges brought by NGOs and individuals. How are they able to afford to litigate?
Yeah, so that's a good question. Yeah, I mean, there's no point in shying away from it. Litigation can be expensive in the higher courts. Some of these challenges are complex, are hearings that run for many days. And it used to be the case that litigation would be prohibitively expensive for some people, unless you were able to get a protective costs order in England or a protective expenses order in Scotland. Really, the big change has been crowdfunding. Organizations, well, let's start first with individuals. Individuals are now able to contribute to crowdfunds that are run by organizations, either through crowdfunding sites or if it's an NGO, through just a donation campaign. And that allows potential challengers to raise quite significant sums of money quite quickly. And that also works, I think, for the firms advising them, because they know that the money is there to pay the costs. So you can combine that with getting a protective costs order. The other option, and this is probably more relevant if you're challenging a company directly, is there's an increase in litigation funding options. So sometimes you can get insurance, which effectively involves the insurer or the funder taking on the risk, the litigation risk, and obviously at the end they would get a portion of any damages. So those are the kind of real, the two big changes. And the other thing, I suppose, is it's more of a practical consideration at the end of the day. I mean, one of the biggest risks in litigation, of course, is if you lose, you'll have to pay your own costs, but you'll also have to pay the other side's costs. And sometimes what we're seeing is in a piece of climate change litigation, even if, for example, the government wins or a private company wins, them not pursuing their costs because of the reputational issues that might create. Now,
that's quite interesting.
But that's not always going to be the case, and of course it's absolutely appropriate to recover your costs, but it's just a policy decision that's been taken by some organisations and some decision makers.
And let's see what else we've got. Is there any prospect of Scotland getting a specialist environmental court or tribunal?
So again, I did mention that other jurisdictions have specialists in environmental tribunals, and it is something that crops up from time to time, and the reason really is because of the limitations in judicial review in Scotland and elsewhere in the UK. So what you might find is those seeking to hold government to account or hold decision makers to account want there to be that merits review, looking at the evidence. What was the evidence base on which decisions were taken to fix targets or decisions were taken to grant particular licenses, and having a tribunal set up to do that as opposed to the more limited recourse to judicial review. There are no plans at the moment to do it. Scotland does now have a new environmental regulator, Environmental Standards Scotland, which was just set up this year and has only gone live with its powers in the last week or so. So it'll be interesting to see how they go on. They're not set up as a new tribunal, but their purpose is to hold government to account in terms of environmental policies. So it might be interesting to see if pressure comes from within that new regulator to see a tribunal or the court system changed in some way, but no immediate plans at the moment.
Okay. And so I think unless anyone has any other questions, we will wrap up there. So thanks, Neil, for speaking today, and thanks also to all of you for joining us today. We hope you found the webinar useful. Our next Energy Academy is taking place on the 26th of October, and the topic is NEC contracts. So please make sure you sign up for that via our website, brodies.com. Finally, a very small request from us. When you leave today, a short 1-minute survey on our webinar and how well we did will come up on your screen. Your feedback really helps us to shape the future for academies, so we would appreciate if you could take the time to complete the survey for us. Thanks again, and goodbye for now.
Thank you all. Goodbye.